Patenting Life, next on International Focus.
The Institute of World Affairs at UWM and Milwaukee Public Television present International Focus, a global magazine linking Wisconsin and the world.
Welcome to International Focus. I'm Rob Rosigliano, Director of the Institute of World Affairs at UWM. Centuries ago, governments developed patents as a way of protecting and rewarding creators of industrial goods and processes. Today, however, the new realities of biotechnology have expanded the realm of patentable products to include living things. Corporations now claim intellectual property rights over seed and plant varieties and other life forms. Critics say this breaches a critical ethical barrier, arguing that patents on these products interfere with the very basis of community food systems. For a look at the issues surrounding the patenting of life and the growing global backlash, we're joined today by Aneesh, Assistant Professor of Sociology and Global Studies at UW-Milwaukee, whose research specialization includes globalization, science, and technology. He's also currently a Global Studies Research Fellow with the Center for International Education, where he is investigating the ethics and implications of patenting life forms. Aneesh, welcome to International Focus.
Thank you, Rob. It's a pleasure to be here.
So, Aneesh, I know that your research is focusing really on a couple of case studies. But I'm wondering, before we get into that, if we could talk, sort of zoom out a little bit and talk a little about just generally what the whole sort of controversy and news is about this idea of patenting life forms.
Yeah, it's amazing that until 1980, life was not patentable. It could not be privatized. It could not be owned. And the U.S. Patent Office held that position until 1980, until it was overturned by the Supreme Court decision, where microorganisms that were manufactured through human ingenuity could be patented. And that started the gold rush for patenting life.
So when you say a gold rush for patenting life, so like physically, like what happens? What has happened?
Then the whole, so first because the genetic sciences were already advancing at a very fast pace in the 1980s since the DNA discovery earlier. So it gave another space for the corporations to grow in terms of creating new plant varieties, new transgenic materials where some traits could be inserted into new plant varieties which they did not have before. So you could make a tomato very strong by inserting a gene of a flounder fish, for example. So very different species could be brought together. And that scope of patenting has turned out to have global implications now, because now we know that corporations like Monsanto or Pioneer own seeds throughout the globe, dispersed in different places, from Africa to Indian subcontinent to Europe, and not as much in Europe, but in the United States definitely.
And so then now a company like Monsanto or a pharmaceutical company can take these life forms, these seeds, and now they obviously their motive is to make profit here, right? So have they begun to realize, is it a profitable business basically?
Oh, Monsanto has grown enormously. Although recently I've been hearing that they're having a hard time. Some of their products are not doing as well. And maybe they have hit a saturation point. All their pricing policy is wrong. But Monsanto's stock prices have gone down tremendously. But at the same time, these companies have grown enormously. I mean, the growth is just remarkable.
So this is a good thing, right? I mean, do we want more productive farmers and better medicines and so on? So isn't this all a good thing?
No, it does have a lot of good things. It does allow faster market innovation and new inventions, and some of them are helpful for medicinal purposes. But then it has two problematic points. One is the ecological point. I'm not going to go into details into that because it's not my field. But still, the ecological uncertainty that they introduce has enormous implications, because human survival in the last 2 million years has been because of certain balance in ecological terms. And that balance can be overturned, can be disturbed, and we don't know. There is a lot of uncertainty. There is no obvious answers whether they hurt the health of humans or not. But the uncertainty itself, or the amount of risk that they introduce into the system, ecological systems, is is something that many people, on ecological terms at least, the theorists, are really scared about. But my point is sociological. I'm a sociologist. And I think this introduces, to me, all technologies and all laws come with societies wrapped up around them. So they do not happen in a vacuum. So once they are there, then a social order has to be changed. And I'll give you an example from the 70s when the environmentalists used to say that in an ideal experiment, if you create a society with based fully on nuclear energy versus a society that is fully based on solar energy, it's not just the technological aspect or the efficiencies gained or lost or the market, the economy that grows or not. The point was that they will produce two different social orders. They will not determine the social order, but in order for them to survive, social order will have to be changed. Societies will have to literally change. So if it's nuclear energy, you will have a more authoritarian society. With solar energy, you will have a more decentralized, something that can grow, society that can grow out of the grid. But nuclear energy, because it's inherently dangerous, that a little small theft could have catastrophic consequences, that allows then the state to start intervening in everyday social life.
Now, the two sort of issues you cite, the sort of environmental uncertainty, which is for people non-scientists like me, I understand to be, if you introduce a genetically modified seed somewhere, how do you know that is not going to be mutated and spread?
Yeah, you can never assure. No one can ensure that, because if you suppose Monsanto has developed this corn that produces certain toxin that kills the larva that kills the corn. But how do we know that it might not affect other butterflies or all other kinds of microorganisms that we need in this ecological world? And
then the other implication of this sort of the complex kind of but different social order that is created around these innovations. Both of those examples, we're talking about change, though, not just in Wisconsin or the United States. We're talking globally, right? Yes. I mean, so if Monsanto is here, but it's operating in a foreign country, right, introducing seeds there or patenting certain life forms, that has by definition then a global implication. So are we really talking about these social changes being huge then?
They are global, and these transformations are global, and partly because intellectual property regime is global. It's covered by World Intellectual Property Rights, and it's also supported by the World Trade Organization. So nations have to follow through. They have to protect Monsanto or any other corporation's patents. So in that sense, and there are also lots of fears, sometimes justified, sometimes unjustified fears associated with genetically modified seeds. For example, in India there was a scare about cotton, and GM cotton was such that a lot of sheep were dying. But we don't know. The causality cannot be proved, and it could be a hoax. It could be anything. But that uncertainty, both in public discourse and in the scientific world, in the ecological world, is something that has to be reckoned, that one must look into before we rush into these areas, which were banned until 1980, literally.
Let's talk some about what are some of these social changes that happen, and you're looking at two case studies in the work you're doing now, and maybe we can start talking about one. We'll have a break coming up in a few minutes, but so Hoodia, which I think people may know from infomercials around diet products. So could you say a little bit about what Hoodia is and what are some of the issues that have arisen with it?
Hoodia is a kind of plant that grows in the Kalahari deserts, and it's been traditionally used by the Bushmen there in South Africa, Botswana, and Namibia to suppress appetite, and it kind of wards off hunger as well as thirst, especially during long hunting trips. But the fascinating thing about the Hoodia is that it can also act, just as it serves a purpose for the underfed, it can also serve a purpose for the overfed. So it suppresses appetite, which means it could be a great potential obesity drug. So the South African Research Council started extracting a particular active ingredient, P57, out of it, and they found that they could patent it in 1995, and then they licensed it to different pharmaceutical companies. And so the interesting thing about this is that there was then local resistance against it. How could you patent something that was already known? And the basic premise of patenting is it should be novel and non-obvious. And if everyone knew about it, but the interesting thing is then there was no counterparty who could actually oppose this claim of the South African Research Council and associated pharmaceutical companies around the globe, including Pfizer for a while. So they created a different social order in the sense that in order for the law to recognize them, they have to create a group. So they created the group called the SAN, which is an actual group in South Africa and all the neighboring countries. But no one knew. A student of mine at Stanford at the time was doing research. She went to South Africa and she found that it's not true that this invention was by the SAN, or they were the only one who knew the properties of Hoodia. Everyone knew the properties of Hoodia at the time, not just the SAN. But in order to win this battle, they had to create a group whose rights were supposedly violated and who could ask for reimbursements of sorts. And this is what exactly happened in their case.
Well, it is this fascinating issue, which is you take something which is common knowledge, but because it was so common, it didn't prevent. You had no aggrieved party to say, hey, we can't patent it because you own it, or it was really your invention, right?
Yes. And the great thing about this is that this is all oral tradition. Everyone knew it, but no one wrote it down. It was so well known that no one needed to write it down. And especially in oral societies, that's a problem. And for positive law, it needs documents. It needs proof. How do we know that you knew? So either has to be a group that comes with its witnesses and its people that claims that they knew this knowledge and they have been using it for this purpose for a long time. And so it's fascinating. It constructed a group as the original inventor of this knowledge.
So we have to reinvent history for the purposes of this sort of legal regime. We just have a minute or two left before the break, and I know we'll be talking about this for a while after the break. But so what now? So what if the SAN? Let's assume that it was only the SAN, right? That sort of fiction actually is real. Have they been injured? And how have they been injured by the patenting of the active ingredient in Hoodia?
Yeah, it's interesting that they were not an injured party. They had just the claim that they were also one of the people who should be counted along with South African Research Council to be the inventors, to be the people who actually patented. So they are kind of party to the case. So in that sense, it was not the tort law that was applied. There was no injured party. But they were they wanted to be the participants. They were the ones who wanted to reap the benefits of this invention. So it's kind of interesting that this local resistance took that particular form in Africa, and was able to gain this 6% commission cut out of all the global sales of any product that uses Hoodia ingredients in it.
Aneesh, we've got to right up against our breaks, but I want to come back to this as a really fascinating question. To our viewers, we'll be back in just a moment on International Focus.
The Institute of World Affairs presents our community with a range of public programs relating to global issues, U.S. foreign policy, and the world economy. For more information about the Institute of World Affairs, call 414-229-3220 or visit our website at www.iwa.uwm.edu.
Welcome back to International Focus. We're talking about the implications of being able to patent life and life forms with Aneesh, Assistant Professor of Sociology here at UW-Milwaukee. So Aneesh, the SAN, this group, is, as you were saying before the break, it successfully argues for a cut of the global sales revenue from this culturally discovered product, and so that's now an income stream. But now the issue of the SAN being or not really actually being a group starts to matter because now you have money involved. So what happens to the money?
That's a fascinating question. It is. So they have created a group, and the group benefits. It could be quite like a class action lawsuit where there are some parties, but still the sales have not materialized as much because it's still not being approved. Although it's on sale in most of the products, especially supplements that we get in the health food shops, but it's still not approved by FDA. And before it does, and after it does, and we will see how this allocated, the resources allocated between them. But there is a SAN group that will receive all the benefits, and then the SAN group will decide how it actually distributes it further.
Now, I can imagine if I were in South Africa and be thinking, well, if this was a generally known technology or discovery, why is this group over here getting the benefit and I'm not getting the benefit, or the society in general is not getting the benefit?
Yeah, that's interesting, because that's what actually my student found in her trip to South Africa, that there was a lot of resentment among other groups who were claiming that this is not just the SAN, everyone knew it. But I think everyone went along with it partly because they really wanted a deal to happen, and they wanted some local benefits to emerge. And there has been some political kind of compromise by the SAN group, with other groups, and how future resources will be allocated and distributed among them. But it's fascinating that because of the controversy, sometimes many companies have kind of opted out, like Pfizer licensed for $21 million, but then they eventually returned all the rights. So it's now a different Unilever that's in the middle of this. So these traditional, struggles for traditional knowledge are having an effect in the corporate world. So it's not as easy as it used to be during the colonial times, that you just go and get it and it doesn't really matter.
So it may be tempering that kind of gold rush effect you'd talked about earlier, which is this is more complicated than maybe we thought. It wasn't like going in and finding the nugget on the ground and taking it. There's all these sort of, as we were talking earlier, all these social ramifications, political, economic, legal, that have to be worked out. Now, you also were looking at neem.
Yes.
And can you tell us about what neem is and why it's significant?
Neem is a big tree. It grows about, I think, 15 meters in India, and it's everywhere in India, in the subcontinent, I think, including Sri Lanka. Neem has been known, and actually I grew up in India as a kid, and I remember visiting my village from the city. They would be giving neem twigs to brush my teeth. It has antibacterial properties. So in the villages, it's been used for a long time. Farmers knew about its pesticide attributes. And almost all, if you look at Ayurveda, the old scriptures, they do have mention of neem in them. And it's more than 2,000 years, I think, since we have had references to neem and its qualities. And everyone in India actually knows it, whoever grew up there. The fascinating thing, when W.R. Grace, the American company, patented its active ingredients, it was opposed by the Indian government first. Because in some ways nationalism comes to help. Then they realize that this private company is going to come and then eventually have a license over this, and then they will start controlling how the neem seeds are used, and they might even reduce the supply of the neem seeds for the local farmers for traditional purposes. So they really fought against them in Europe, in the European Patent Office. And in 2 cases, they won the case. So the difference between Hoodia and neem is that while Hoodia participates in the intellectual property culture, in the sense that it's not opposed to patenting itself, while in the case of neem, uses the biopiracy language, the language of biopiracy, and fights against patenting altogether, that there shouldn't be any patents. So in the Hoodia case, we have patents and they agree to it. All parties agree to it. But in the Indian case, they don't agree to any patent there, although now we do have a lot of patents on neem. But those 2 cases actually had an enormous effect on the kind of social order that might emerge out of it, in the sense that now companies cannot just go in any country. There are national laws, they are protected by World Intellectual Property Right regime itself, that they have to ask for permission from the governments, from the local groups, before they can do any scientific research, before they can pluck any flower out of any country. So it had an enormous influence on this issue, the neem issue.
So in the first battle over neem, if it had become the property of W.R. Grace, they literally would have been able to control use of it in the country?
As you know, the patents, they try to apply as broad a patent as possible, almost owning the seeds themselves.
Right.
And then, of course, they negotiate in the patent office and how much of that can be patented, and whether it's just the process, just the method, or the seed itself. But they were able to patent. So the supply issue was related with the use, because if they found it out and they started the global supply of fertilizers based on this, global supplies of pesticides based on neem, then they will be consuming all the neem seeds in the country. That will reduce the supply in the country for the local farmers, because they are otherwise very cheap.
So it may not have been a legal issue, it was a practical
economic issue.
Yes. They create this huge market for it now, and it no longer can serve its traditional purpose. It serves this global economic purpose. Now, they were successful in sort of at least slowing that process down.
Yes, the two patents were revoked, actually, in the case of W.R. Grace. So they were not able to patent. The European Patent Office denied them. And the companies then, since that case, it's also interesting, legally, they have have been following a different method. Now they try to, instead of a blanket patent through the biggest office in Europe, they try to go through different countries and get it passed there. So then it doesn't create as big an opposition. It doesn't create as big news. So people don't hear about it. So it's a kind of a lot of interesting legal battles and legal.
So you might seek the patent on neem in France or in Brazil or wherever. Is the effect the same, though, eventually, that you again create this kind of global market that swamps the local demand?
It might, but it might not. But because now Indian government is taking an active interest. So because it's not, they don't hold the property rights to it, Indian government can actually create restrictions.
So is the government then the only one who's really in a position to basically speak for? This is a cultural tradition that's gone on for at least 2,000 years. Are they the only ones who can sort of speak on behalf of that public?
No, actually, that's a great question. It was kind of started by the NGO and the NGO with which Vandana Shiva was associated with, the famous environmentalist in India. And she started campaigning against this patent. And at the time, Indian government also got interested. So it's a combination. Later on, in the 90s, Vandana Shiva, along with some NGOs in Europe, was able to get the patents revoked. So it might have been started by the Indian government earlier, but it was the NGOs, these non-governmental organizations, that what they call the global commons. They're fighting for the global commons, and they were able to gain a lot of rights.
It seems we're coming down a few minutes left, but I confess to having a law degree, so this is piquing my old legal interest here. So it seems as though in the solution that applied in South Africa wouldn't really happen or couldn't happen in India, because you unless like all of India was given a percentage of the. In other words, is because neem is so deeply rooted throughout Indian society that you can't have like the horse is out of the barn. You can't subject to the traditional intellectual property protections.
Yeah, I mean, and it's a wonderful question, because that actually makes me think whether it was something about neem, because it is actually deeply rooted in the whole subcontinent, in everyone's consciousness. It's on every street that you see. But I do wonder because in the case of South Africa, the original patent was filed by a South African research council. And in the case of India, it was an American company, W.R. Grace, that tried to patent it. So there might have been nationalism at work here,
sure.
in India's case.
So it certainly, it felt more like this was being taken away.
Yeah, it's like old colonial appropriation, reminding them of the British times.
So we have just a couple minutes left, and I'm wondering, Aneesh, if you can speculate a little bit about as to where you think, or how these two case studies make you think about where's the future going generally when it comes to patenting seeds and life forms.
As you know, with every form of this kind of private appropriation of public resources, there's always going to be resistance. And I'm kind of hopeful about it for both the ecological reasons and social reasons. As you know, that in the States, we have a very strong organic movement. And people used to think or tend to think about organic movement as just about health-related issue. I think organic movement is more about, it's a political economy issue, in the sense that if we consider the old idea of property, that you own your land, which means now we don't actually. In the case of Monsanto, they can bring a lawsuit against you over your own land if their seeds are growing on your land. So the interesting thing of the property as being material and land and house-based is being overturned by intellectual property. And so the global commons movement is kind of is the only way to kind of resist this, but also by participating through organic movement in the global economy and market economy, they are able to offset some of its. So I think in the future what we are going to see more and more of these two forces, private versus semi-private and public, fighting and engaging in this battle, and maybe some compromises might result on it from it. But I doubt if the patent on life, that legal, one single Supreme Court decision could be overturned.
Well, Aneesh, thank you so much for introducing us to this really fascinating issue with many, many deep economic, political, and social roots. And I think we'll need to be watching this in the years to come, so we'll hope to have you back at some point.
Thank you very much, Rob.
Thanks to our viewers. We'll see you next week on International Focus.
For information about the Institute of World Affairs and its many programs, or to become a member of the Institute, call 414-229-3220, or visit us at our website,